Hello there. This is An Architect Goes to Law School. Today in civil procedure class, we'll start talking about the phases of a lawsuit, specifically the initial pleadings. The rules of civil procedure establish a framework that lawyers and litigants must adhere to in trying their case in court. These rules dictate how the suit must start, the initial pleadings, what happens during discovery phase activities, in pretrial motions, at trial, and how to appeal the judgment. It should be noted that some of the lowest level courts, often called small claims or justice of the peace courts, are allowed to deviate from a state's rules for civil procedure. Rules of evidence are not necessarily followed strictly. Court proceedings do not always have the same motions and procedures. It is a best practice to consult an attorney and the court's local rules to determine how these courts engage in their proceedings. The first formal steps in any lawsuit are the drafting of a petition, which in federal courts is called a complaint, and filing it with the appropriate court. Petitions are the way that a civil trial plaintiff makes the court and the defendants aware of the claims being presented to the court. Federal Rules of Civil Procedure, Rule 7, Pleadings Allowed, Forms of Motions and Other Papers, regulates the initial pleadings in federal court. In addition to the complaint and answer, other initial pleadings of counterclaims, cross-claims, and third-party complaints have to do with claims raised by parties other than the instigating party. A counterclaim is one raised by an initial defendant against the plaintiff. A cross-claim is one by a plaintiff or defendant against a similarly situated plaintiff or defendant. In general, because all claims arising out of a particular set of facts and events must be dealt with at the same time for reasons of judicial economy, sometimes co-plaintiffs or co-defendants raise claims against each other as part of a single instance of litigation. If not raised at the appropriate time in the litigation, those claims may be prevented by a doctrine called claim preclusion or res judicata. Third-party claims are those brought by an original defendant against another entity, bringing them into the lawsuit as a third-party defendant, making the original defendant a third-party plaintiff. Joinder is a procedure by which an individual or entity that was not a party to the initial action intentionally joins the litigation in order to resolve its related claims so as to not lose its opportunity to do so. FRCP 8, General Rules of Pleading, controls what must be included in a document that states a claim for relief. Rule 8A states, quote, "A pleading that states a claim for relief must contain 1. A short and plain statement of the grounds for the court's jurisdiction, unless the court already has jurisdiction and the claim needs no new jurisdictional support. 2. A short and plain statement of the claim showing that the pleader is entitled to relief. And 3. A demand for the relief sought, which may include relief in the alternative or different types of relief." End quote. Appropriate notification of the facts of the suit, called notice pleading, is the current pleading standard for federal civil complaints. Two Supreme Court cases, Bell Atlantic Corporation versus Twombly and Ashcroft versus Iqbal, held that, quote, "Factual allegations must be enough to raise a right to relief above the speculative level," end quote. If a defendant challenges the sufficiency of the petition based on Rule 8A2, the judge must determine whether the petition states a plausible claim for relief, not just one that is possible. Once served with the complaint, defendants are required to file an answer with the court that is then transmitted to the plaintiff and other parties. Answers can contain various pieces of information, such as confirmation or denial of any or all of the allegations in the petition, as well as counterclaims and cross-claims made by the defendants against other parties. Denials of the claims can be general or specific. It's common for a defendant to include a general denial of the claims so as to require the plaintiff to prove all the claims in court. Importantly, an answer to the petition is an opportunity to state procedural and affirmative defenses. We'll discuss those procedural and affirmative defenses in the next video. Three procedural elements of initial pleadings and answers in civil lawsuits are subject matter jurisdiction, personal jurisdiction, and venue. Subject matter jurisdiction simply means that a particular court, such as a district court or county court, has the constitutional or statutory power to hear the particular cause of action being brought before the court. One state court example of this is that in Texas, a breach of contract cause of action cannot be accepted by a statutory probate court, but can be heard in certain other courts. Personal jurisdiction means that the intended defendant can be required to submit to the courts of that state or federal district. Venue means that a court is in the correct location to hear a case. Two statutory examples of this are that some states have venue requirements such as county of residency of the defendant, or that a suit must be brought in the county where the injury occurred. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up, we'll discuss procedural and affirmative defenses. Thank you for watching. An Architect Goes to Law School.